is overruled. The respondent's reliance on Republic vs. Eugenio is unavailing. That case involved only an ordinary civil inquiry into spousal assets that were not statutorily aggregated. On the other hand, Section 8 of Republic Act No. 6713 requires public officials to disclose their assets, including that of their spouses. Their financial interests are therefore statutorily intertwined for purposes of disclosure. Respondent likewise insists on the separate legal personality and distinct right to privacy of Attorney Carpio, but this is likewise untenable. Article 75 of the Family Code explicitly provides, which is why the presiding officer earlier asked the property regime governing them. In the absence of a marriage settlement or when the regime agreed upon is void, the system of absolute community of properties established in this code shall govern. Under this regime, Article 91 dictates that community property shall consist of all the property owned by the spouses at the time of the celebration of marriage or acquired thereafter. Furthermore, the Family Code imposes a strict statutory presumption under Article 93, which mandates that property acquired during the marriage is presumed to belong to the community unless it is proved that it is one of those excluded therefrom. The law is clear on the matter. The legal necessity of examining the financial records of Attorney Carpio is firmly cemented by the default property regime of absolute community of property governing his marriage to the respondent. Absent any proof of a different property regime governing their marriage, any funds deposited in the bank accounts of Attorney Carpio are legally presumed to form a single, indivisible mass of community property jointly owned with the respondent vice president. Because Philippine civil law legally merges their assets, properties, and income into a single absolute community, it is a legal and mathematical impossibility to determine the respondent's true net worth or lawful income without examining the bank accounts of her husband. Investigating Mr. Carpio's financial records is therefore not an unwarranted intrusion into a third party's privacy, but an absolute legal prerequisite in determining the actual aggregated wealth of the respondent. The defense likewise invokes the Data Privacy Act, classifying the records as sensitive personal information, requiring strict scrutiny, quote-unquote, citing Zoleta versus Ombudsman. The court, however, in Zoleta did not really use the phrase strict scrutiny, but said strict adherence to the Data Privacy Act. Accordingly, Section 16B of the Data Privacy Act expressly states that the right to privacy does not apply when personal information is needed pursuant to a subpoena. Furthermore, Rule 5, Section 22F of the DPA, Data Privacy Act Implementing Rules, expressly permits the processing of sensitive information, personal information, when provided to government or public authority pursuant to a constitutional or statutory mandate, and when necessary for the protection of lawful rights, interests in court proceedings. Now, as to the 21 listed corporate entities and partnership, the requests are granted with respect only to 19 corporate entities and partnership. The respondent's connection to these entities is prima facie shown by the general information sheets in the articles of partnership, which have been pre-marked in evidence, and by her admitted sal-ends from 2022 to 2025. The request, therefore, is not considered as a fishing expedition, and subpoenas may issue for their peso-denominated accounts strictly only in relation to Article 2. However, the request directed to banking institutions concerning JTC Group of Companies and Pikimong Philippines Corporation are denied. Their general information sheets do not identify the respondent or her spouse as shareholders, and the prosecution at this time failed to show either a direct business interest or a clear and convincing basis to disregard their separate juridical personalities. As held in Pantranco Employees Association v. NLRC, GR 170689, and Lanuza versus BF Corporation, GR number 174938, the corporate veil may not be pierced on mere suspicion or speculation. Misuse of the corporation as an alter ego, conduit, or instrument of fraud must be clearly established. Absent such proof, these entities cannot be subjected to the compulsory process intended for another. As to the request for subpoena against the partnership of Carpio lawyers, the same is granted with the following reservation: in adherence to Subido versus Pagante Certeza Mendoza and Binay Law Offices versus Court of Appeals, GR number 216914. The chair notes the practical reality that an examination of a law firm's bank accounts may incidentally disclose sensitive information relating to its clients and legal engagements. The court acknowledges that the partnership and/or the clients of Carpio lawyers may seek appropriate remedies and to challenge compliance with applicable legal requirements, particularly in light of the potential legal implications, including concerns relating to attorney-client privilege, which may also be raised during the trial proper. Furthermore, the court must draw a legal firm line regarding foreign currency deposits. Foreign currency deposits are governed by Republic Act No. 6426, particularly Section 8, which recognizes only one exception to confidentiality, the written permission of the depositor. This is also guided by the President arising from the 2012 Corona impeachment trial. On February 19, 2012, the Supreme Court issued a temporary restraining order in PS Bank versus Senate Impeachment Court, GR number 200-238, enjoining the Senate from opening the Chief Justice's Corona dollar accounts in the absence of a written waiver of the depositor. Accordingly, insofar as the request covers foreign currency deposits of the respondent, her spouse, separately or jointly, as well as the corporation and partnership, it is denied. Such accounts shall be excluded unless and until a written consent of the respective depositors is produced. The court now turns to the records held by the AMLC or Anti-Money Laundering Council. As to the request directed to the Anti-Money Laundering Council, the same are granted with respect to the respondent, her spouse, and the 19 entities and one partnership for which a prima facie connection has been shown through the pre-marked general information sheets, articles of partnership, and the respondent's admitted salens. However, the requests as to JTC Group of Companies and Pikimong Philippines Corporation are denied for failure at this stage to establish a prima facie link, the respondent or her spouse and said entities, or any sufficient basis to disregard their separate juridical personalities as previously stated. The defense vigorously argues that AMLC is absolutely shielded from this court's compulsory process by the confidentiality provisions of Section 80 of the Anti-Money Laundering Act, as amended, and warrants that compliance would expose AMLC officers to criminal sanctions for breach of confidentiality. The court, however, finds this argument unavailing. Section 8A regulates unauthorized and arbitrary disclosures by AMLAC personnel. It does not and constitutionally cannot nullify the lawful subpoena powers of the Senate sitting as an impeachment court, where compliance with the lawful constitutional subpoena is a justifying circumstances that, if at all, would extinguish any penal liability under Article 11, Paragraph 6 of the Revised Penal Code for any person acting in obedience to an order issued by a superior or some lawful purpose. In the landmark case of Republic versus Sandigan Bayan, GR 2322724, the Supreme Court explicitly rejected the AMLC's attempt to quash a subpoena ducis tecum, ruling verbatim, quote, "The Anti-Money Laundering Council is not merely a repository of reports and information on covert and suspicious transactions. It was created precisely to investigate and institute charges against those suspected to commit money laundering activities. The criminal prosecution of such activities would be unduly hampered if we were to prohibit it from disclosing such information. For the Anti-Money Laundering Council to refuse disclosing the information required of it would be to go against its very function under the law." Further, as held by the Supreme Court in Sabio versus Gordon, GR number 174340, by parity explained that statutory provisions on confidentiality and exemptions from inquiry cannot be invoked to deny access to information by Congress in aid of legislation. It is therefore the position of this court that if the Sandigan Bayan, pursuant to its subpoena powers, cannot be denied AMLC records as well as the legislature in aid of legislation, it most certainly cannot be denied to the Senate, sitting as an impeachment court. The defense also vehemently objects to the production of AMLC documents by pointing out to the agency's own printed footnotes, which restrict the reports for intelligence purposes only, quote unquote, and explicitly state they are not to be used as evidence in any formal proceedings. The court, however, overrules this objection.